Motion for a new trial. State of Arizona versus Lori Daybell, defendant. Lori Daybell requests the court grant her a new trial pursuant to protections provided by Rule 24.1 of the Arizona Rules of Criminal Procedure, blah, 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 blah. Memorandum of Points and Authorities. Fourth Amendment violation, medical evaluation. On Friday, May 30th, the defendant became ill, vomiting at the lunch break during jury selection. So she did vomit. I wondered how she knew she was ill, or how they knew she was ill. So she threw up at lunch. After lunch break, the defendant informed the judge and the state of her sickness. Sickness is a different matter, Lori. You were ill, of your illness. We already knew about your sickness. We still know about your sickness, but we didn't know about your illness, details of it. Reminds me of the Disturbed song, Get Down with the Sickness. And that her investigator had also been out sick since the prior day with the same symptoms. The court asked defendant to stay for 10 minutes while he informs jurors and releases people with schedule conflicts. The defendant was reluctant and did not want to vomit in front of the jury. However, the judge refused to dismiss her. The 10 minutes turned into 1.5 hours. Before being dismissed by the court, he advised defendant to let the court know through her team before Monday if she was still sick. She's still sick. She's still sick today, but I don't know if she's ill or not. On Sunday, June 1st, defendant was still sick and had her advisory counsel email the court to inform they that she was still too sick with a virus and could not proceed on Monday, June 2nd. Monday, June 2nd, the defendant was very sick. It's so funny that she's substituting the word ill for sick, because she is sick. She's a sick individual.
Mm-hmm.
And it's like a Freudian slip. She keeps using that instead of ill. And it had advised the court in a timely manner. However, the court sent an order to the jail on June 2nd to have defendant brought to court by any means necessary. Defendant could not walk from being weak and dehydrated, having vomited all weekend. MCSO brought defendant to court in a wheelchair. Defendant then explained to the court she was too sick to represent herself and would not go forward. The court again asked the defendant to stay while he brought in potential jurors to explain, and ordered her out of the wheelchair into a regular chair. The defendant argued that the last time he said 10 minutes, which took over 1.5 hours. So she's arguing her own arguments, which were ineffective the first time. Sounds like a great legal strategy.
Mm-hmm.
So he dismissed her prior to dismissing the jury. Defendant was then left in the wheelchair in a holding cell with no blanket, medicine, or hydration for 6 hours. Ooh. Waiting for transport back to the jail. That's not good.
That's rough. And that happens. They'll leave you sitting in the holding as long as they need to.
Yeah, and you know what? One of the reporters that was there for the trial, that's a local reporter that has covered other cases and trials that are not necessarily this high profile, has said that inmates will complain about that on a regular basis, that they're left in that holding cell and they don't get blankets and they're freezing and they're hungry and they're thirsty and they just basically get put in that holding cell and held there.
They do.
Until the transport van is ready to take them back.
Happens all the time here in our county jail. So the girls that I've talked to that's been in the county, they'll tell you the same thing. You will literally sit there for hours and hours. I mean, I get it. They're in jail and they're criminals, but they still have some rights. Like their rights, then you jeopardize their cases.
Right. Yes. Got to make sure their rights are taken care of. Does it rise to the level of needing a new trial? No.
Now they should have just threw her a blanket and gave her a bottle of water and she'd been fine. It is what it is at some point, but still, people don't care. It's Lori, so but I can't be that way. If I want to uphold the Constitution, I can't let it only apply to the defendants I like. Right? It has to apply to all of them.
Right, and it's the same thing with police investigations.
Yep.
They need to be done right, so we get the right guy or gal, and justice is served through due process.
We've seen too many stories lately about how they really fudge up a case because of dumb things they do.
On Monday, June 2nd, 2025, the court sent an order to Maricopa County Sheriff's Office requesting that they medically evaluate. Okay. On Monday, June 2nd, 2025, the court sent an order to MCSO requesting they medically evaluate defendant, a violation of this defendant's Fourth Amendment rights, and Arizona Constitution, Article 2, Section 8. June 3rd, 2025, MCSO called defendant out of bed again to walk down to medical. MCSO ordered CHS to evaluate the defendant's health without her knowledge. MCSO ordered CHS to evaluate defendant's health without her knowledge. CHS then provided their evaluation to the court through MCAO's civil attorney, Joseph Vigil, which was a HIPAA violation. Notice filed on June 3rd, 2025, initially not under seal. On Wednesday, June 4th, 2025, this court ordered again defendant to court by any means necessary. Order to MCSO. Any means necessary order means guards show up at your cell and pull you out of bed and take you to court against your will. Once in court, defendant again informs the judge that she cannot proceed because she is too ill. Judge Boreski orders her not only to stay, but to defendant herself while too sick to do so. Defendant was then forced by the court to voir dire the jury and select a jury. You know, I was there for all of that, and I never saw her throw up one single time. Like, don't you think if you really wanted this to turn into an issue that you would throw up in front of the jury? But no, she acted and interacted with the jury fairly normally, besides like when she was at the podium, like standing hunched over, so in case her belt might show to the jury, then she could get a mistrial. Thursday, June 5th, 2025, although defendant was still suffering from a viral illness, she was expected by Judge Boreski to give her opening statement and begin cross-examining witnesses, which she did, I mean, fairly normally. I didn't see any behaviors that were different from the first trial. Friday, June 6, 2025, Judge Boreski ordered defendant by any means necessary to again defend herself sick in a full day of court from 9:30 a.m. until 4:30 p.m., which she was able to do. Sunday, June 8, 2025, defendant's advisory council again emailed the court that defendant is still sick and that she had been notified by CHS of the results of the testing performed, came back with an infection in need of antibiotics for treatment. Yet again, a by any means necessary order was entered by the court for Monday, June 9th, on which day Judge Boreski cleared the courtroom and sealed the hearing now that there was actual evidence that the defendant had really been sick the whole time without treatment. In the end, Judge Boreski still ordered defendant to defend herself at trial, knowing she was too ill to proceed. The by any means necessary order continued from Judge Boreski, continued every day through trial from May 30th until June 12th, the day the verdict was given. This is a violation of defendant's due process rights under the 5th and 14th Amendments of the U.S. Constitution and Article 2, Section 4 of the Arizona Constitution. This alone constitutes a new trial. The court precluded this defendant from presenting her case by not allowing defendant to argue objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents from him prior to cross-examining witnesses. To begin, this defendant, in attempting to cross-examine the case agent regarding the investigation done at the scene by initial responding officers, was denied that opportunity. FTR June 9th, minute 3:50:31. The initial responding officer spoke with a witness who provided a different description of the Jeep she saw during the incident. Defendant attempted to cross-examine the case agent when the state objected to the answer based on hearsay. The objection by the state was sustained. Defendant, even though not having been asked for a response from the judge, argued the statement was not being used for the truth of the matter, rather to show effect on listen. Defendant requested a sidebar and was denied. The same interaction occurred with another scene agent, Detective David Frerer, when defendant attempted to cross-examine him regarding what other neighbors told police they heard during police investigation. A hearsay objection was sustained without allowing defendant an opportunity to respond. For the record, June 6, 2025, minute 9:55:02. Lastly, defendant put on the record early in the case that her investigator, Jeff White, had been out ill. The court requested defendant's advisory counsel work with investigator White to obtain documents and exhibits she would need to cross-examine witnesses. Photos were received by advisory counsel and were not able to be printed in time to use during the cross of Detective Frerer. Those exhibits are attached as Exhibit 1. So that was the day that Pam Hicks was late to court, because she was told that morning, last minute, that Lori wanted them printed out, I assume, and was having trouble printing them out and was late to court and got scolded pretty good by Judge Boreski for being late to court. Defendant was also unable to admit exhibits 192, 193, and 194 as the state and the court continued to state she would be opening the door to her prior convictions. Additionally, the state continuously stated defendant's line of questioning relating to Melanie Boudreau constituted a third-party defense, yet defendant never attempted to blame Melanie Boudreau for the crimes. Whew, you sure did some insinuation though, lady. Defendant was simply attempting to cross-examine the victim, Brandon Boudreau, as to why he blamed the defendant. Exhibits 192, 193, and 194 are attached as Exhibit 2. And I got to disappoint you, they're not included in this. We don't get to see what she wanted to present as these exhibits. They were not included in the court filing. The judge is a big meanie. Trina K is a big meanie. Every time Trina K has an objection, he grants it, and he never grants any of her motions, ever. Abuse of discretion, denial of Rule 13.5 hearing. On May 29th, 2025, after reviewing juror electronic questionnaire, defendant requested a probable cause hearing on aggravating circumstances pursuant to Arizona Rules of Criminal Procedure, not releasing the jury from admonition on record. Oh my gosh, I noticed this in court.
I know
After
you
the
did.
ver-
I know. And I
after-
thought about that when I read it, Joe. I was like, oh, wow. Because I remember you telling me that that happened. You were discussing that.
Nate was there, and I asked him, I was like, did he just like put the court in recess without releasing the jury? Not releasing from the jury from the admonition on the record. After the verdict was read on June 12, 2025, the court dismissed the jury so that the parties could discuss whether an aggravation phase would be presented. After discussion relating to the denial of the Rule 13.5 hearing, the court set a sentencing date and dismissed the parties without bringing the jury back into the courtroom to officially lift the admonition and dismiss the jury. This is true. This happened. And I would need to speak with an attorney or someone who is a legal expert to know if that matters. And I said that when we did that recap that night, I think with Trial TV Live, I think I mentioned that. All right. Allowing GSR and DNA evidence without sufficient foundation and denial of right to confront witnesses. This is that Tammy Lachik thing.
I think she's in trouble.
She might be in a little bit of trouble, yeah. All right. So allowing GSR and DNA evidence without sufficient foundation and denial of right to confront witnesses. On May 3rd, 2025, the state filed a motion to preclude Brady material relating to the crime scene tech Tammy Lachik from Gilbert Police Department, who collected material evidence from the alleged crime scene, this being the Jeep in Idaho. Brady material showing that the witness Lachik was implicated in an incident that resulted in her resignation was disclosed by the state on May 1st, 2025, even though the report was concluded on March 6th, 2025. Because of the late disclose, defendant requested the court order the state to disclose the witness Lachik's employee file so that defendant could thoroughly investigate any issues that might be relevant to this witness testifying at trial set to begin on May 29th, 2025. The court denied this request. On May 25th, 2025, the state notified defendant that 2 pages of this witness Lachik's notes, which other forensic scientists would have needed to rely upon or had relied upon, but were now missing and could not be provided to defense. On June 3rd, 2025, in the middle of trial, the state disclosed a letter from the witness Lachik's indicating that she would not be testifying. Defendant Exhibit 203 marked for appellate purposes. Defendant objected prior to each forensic scientist, 2 from Mesa Crime Lab and 1 from Phoenix Crime Lab, to the witness testifying about analysis they completed based on the work conducted by witness Lachik. The first witness was Emilyn Cepanoso, who created a profile from the blood blots collected by this witness at the autopsy of Alex Cox. The second analyst was Vanessa Mielke, who testified that the blood blot profile of Alex Cox matched DNA swabs taken by witness Lachik from the Jeep Wrangler. Finally, analyst Kyle Mueller, who testified about GSR particles found inside the Jeep that were collected by witness Lachik. Those objections were denied. Argument and authority. The Arizona Rules of Criminal Procedure provide that the court may grant a new trial for any other reason not due to the defendant's own fault. The defendant has not received a fair and impartial trial. Fourth Amendment violation, medical evaluation. The new trial is appropriate. By forcing the defendant to proceed with trial as her own counsel, deprived her of the right to effective assistance. By forcing defendant to proceed with trial as her own counsel, deprived her of the right to effective assistance of counsel. Yikes.
Nobody forced her to be her own lawyer. That was her choice.
There is no honor in forcing this defendant to defend herself sick. There is no honor in ordering by any means necessary to ensure that you will be the judge to preside over this high-profile case. Wow, this is like a middle school debate speech. What does honor have to do with it? Does she get sick of having to call him the Honorable Judge Boreski? Is that where she gets the word honor from it? Paragraph B, a defendant may move for a new trial based on the court's lack of impartiality. And she's argued this like 4 times now, that Judge Boreski is not impartial. Defendant may move for a new trial based on the court's lack of impartiality. While under the law, a trial court is presumed to be impartial and free from bias. The defendant can rebut this by the preponderance of the evidence by showing the court required her to present her defense strategy to the state before calling any witnesses, by denying the defendant a thorough opportunity to present her case, by preventing defendant from arguing objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents. from him prior to cross-examining witnesses, this court established a lack of impartiality. During cross-examination, defendant was not allowed opportunities or even asked for responses to state's objections. Defendant was continuously admonished not to speak over the court. Yet when courts generally request a response from defense regarding objections, this defendant was not afforded that opportunity. When defendant attempted to explain why a statement was not hearsay because it established how the police investigated the case, the court spoke over the defendant. The court spoke over the defendant, telling her the objection was sustained. When the defendant requested a sidebar, it was denied. That when the court spoke over the defendant, oh my gosh, he's a piece of work. By not allowing defendant to question witnesses relating to Melanie Boudreaux and how that could have impacted victim Brandon Boudreaux' thoughts on why he blamed defendant, this court showed a lack of impartiality. Any attempt to present defendant's case was met with threats of informing the jury about defendant's prior convictions. Yeah, it's called opening the door, Lori, and you were actually being protected from that. That's not a threat. That's a protection for you. And Trina K just got sick of it, and her rebuttal on closing was just masterful. Like, she was on fire. She was sick of it too. Abuse of discretion. Denial of Rule 13.5 hearing. The court abused its discretion by denying a probable cause hearing under Rule 13.5 on the aggravating factors alleged by the state. This is a flat out lie. The judge asked her if she was doing it voluntarily and if anybody had coerced her into it, and if she understood the ramifications and consequences of stipulating to the aggravating factors. This is crazy. This is like a whole nother level of delusional.
The girl's not right in the head. She hasn't been for years.
After these two trials, I really believe it. And all of these filings and the arguments that she makes in court and in these motions. The court abused its discretion by denying a probable cause hearing under Rule 13.5 on the aggravating factors alleged by the state. There is only one sentence allowed for the crime of conspiracy to commit first-degree murder, and therefore the state should not have been allowed to argue aggravating factors. The court abused its discretion by denying defendant a Rule 13.5 hearing. No, he said we could have one. Not releasing the jury from the admonition on the record. I already talked about that. Court abused its discretion. Allowing GSR and DNA evidence without sufficient foundation. This defendant was denied her Sixth Amendment right to confront all witnesses. A clearly material witness was allowed to not be called. Well, you could have put her on the defense list and you didn't do that. You put she put Moffitt on the list and he was actually served with a subpoena. So why didn't? Well, you know why she didn't subpoena Tammy Lachik, because she thought Tammy Lachik was going to come in and testify because she was on the state's witness, and she was until she resigned. Defendant denied Sixth Amendment right to confront all witnesses. A clearly material witness was allowed to not be called, and then other analysts were allowed to testify to her work product in violation of Smith versus Arizona and the U.S. Confrontation Clause 602 U.S. 779, 2024. Further, defendant was precluded from investigating witness Lachik's employee file to see if there were other issues that would be allowed as impeachment evidence during trial. The court failed to conduct any evidentiary hearing and only issued a minute entry stating that the events happened after she collected the evidence. By preventing defendant from conducting an independent investigation into witness Lachik and conducting an evidentiary hearing, it abused its discretion. Conclusion. The state of Arizona does not honor the Constitution of the United States. The state of Arizona does not honor the constitutional rights of the accused or even the civil rights of the accused. For this purpose, a new trial is required. Respectfully submitted this 23rd day of June, 2025. Lori Daybell, prisoner number G062213. She's got to put some of it in there for appeals purposes, and she's got to file within 30 days. So I'm not surprised by this. I'm only surprised by her level of delusion.